Alright, let's get started. Thanks so much for taking lunch with us to hear from our speaker, Allan Hutchinson. We can't wait to hear all about his new book. He didn't pay me to do this, but I know he worked a long time on it. Fighting Fair, Legal Ethics for an Adversarial Age. And lucky for us, we get the synopsis. We don't have to read it. We can buy the book, and we're going to hear it straight from Allan. Allan holds an LL.D. from the University of Manchester and is a member of the Gray's Inn. He has been a professor and an adjunct professor at lots of different places, but he's still a professor at Osgoode Law School at York University, and he's been there since 1982. During that time, we had lots of different visiting appointments around the world, so we are looking forward to hearing the geographic perspective around fighting fair and legal ethics in today's adversarial age. And he was also a visiting professor among lots of places, but here. In 2007, he taught a seminar for students, many students here. And he has published and edited not just this book, but another 19 books that are around ethics and the common law. He's also published lots of essays and notes and is well known for his speeches, and we are excited to have him here today.
Well, it's always nice to get the applause first. Who knows what follows. Whoever that person was that was introduced, I'm here instead of that person. So, when I came here on Sunday, we went through customs, and one of actually it was the nicest customs officer I've ever had come into the States. He said to me, "You say you're here on business, what do you do?" I said, "I'm an academic." "In what?" I said, "Law," and then immediately, "Oh." And then he wanted to engage about the legal profession and saying, "Oh, the legal profession," and he fitted into that stereotype that people have about the legal profession. They sort of want good lawyers when they're in trouble, but they have a very low opinion of the legal profession. And in some ways, I'm kind of concurring with this idea about the legal profession. I think, in many ways, our reputation is a little bit in tatters. We don't have a good image. We're up there with car salespeople as part of this, telemarketers maybe. That's people's opinion. There's some truth to the criticism. Of course, it's not also fair because I think you could say, to put it in terms that I'm going to talk about, somebody has to do some dirty work, you might describe, and we need to talk about how to do that. So I've tried to think about legal ethics. I'm not going to give a great deal of time to our existing model of legal ethics. I'll say what I see as the flaws and then move into really a more constructive idea about how we might rethink legal ethics. So, I think too often legal ethics turns out to be an apology for existing practices. Legal ethics turns out simply to be the ethics of lawyers, and it suits what they do. The traditional model, I think, suits very much the idea of big business law. The idea now that it's a profession, but it's also a business. And it says, I think, often to business, you can do what you do and still go home at night and saying, "I'm doing a good job. I'm being ethical." But I want to take to task the model, the traditional model of the legal profession, and say, in fact, apart from its many problems, one of them is that it runs out when you need it most. It's full of grand phrases about being honourable, about acting with integrity. But the problem is, we're never quite clear what that means in any situation. So, what we need, I think, is more resources for us to think about ethical problems. I don't think we need more codes that tell us the so-called right answers. I think what we need is something that gives us the resources to think about ethical problems. One is we need something that tells us what is an ethical problem. I think one of the problems for lawyers sometimes is they don't recognize problems as being ethical. Once we can recognize it, we need a sense of judgment about how to think and deal with it. Some ways, some guidelines, some framework in presenting these problems to ourselves. And thirdly, which I think is underrated or underplayed is we need a certain commitment to following through on what the ethical answer is. That often many people are in a situation where they sort of know what's the right thing to do, but they don't do it for all kinds of different pressures upon them. And in many ways, lawyers are in that situation where the traditional model of lawyering allows them to waver on the idea of doing the so-called right thing. So, in many ways, legal ethics often turns out to be simply don't act unlawfully. That it's somehow okay to do what we do as long as you don't break laws. Now that's a very stark vision, and I don't mean to condemn all lawyers or all the profession, but a worrying aspect is that we've slipped into a situation where in advancing the interests of our clients, we can do whatever isn't unlawful to do, and that we just abide by the codes of professional conduct in a very rule-based fashion. And what we don't talk about enough is this last thing: what is it to be a good lawyer? What is this persona, this image that we might have about being a good lawyer? So my book's devoted to try and raise that issue and to pursue that issue. So let's just briefly talk about the traditional model. The traditional model is the hired hand. That we're there to serve people. It's a very technical idea that we don't do a great deal. We have clients of interest, they say what their interests are, and we advance those interests in a vigorous or even zealous fashion. I always have problems with the idea of lawyers as zealous advocates, because I think the phrase zealous doesn't take us down the right road. We think about zealots. This is not something that we should be thinking of as lawyers. But it's the idea that we robustly follow the interests of our clients, and one of Harvard's professors, I still think he's teaching, is Charles Free. He talked about the lawyer being the client's best friend. That you need someone who's in your corner if you're a client, and a lawyer can do that. Now this leads to the idea that we should have strong role differentiation. That when we're lawyers, we're in a role that's something separate from who we are as individuals. So we leave home in the mornings as us, and we get to work, and we sort of become someone else. And this leads to the famous challenge by Thomas Macaulay, a 19th century scholar, who said, whether it be right that a man should, with a wig on his head and a band round his neck, do for a guinea what, without these appendages, he would think it wicked and infamous to do for an empire. And what is the possible rationale for saying that when you become a lawyer and you're paid, then you do for your client what would otherwise be wicked and infamous to do for an empire? And the idea of the traditional model is somehow to try and justify this. I don't have problems with the idea of this role differentiation, but what I want to try and suggest is not that there should be no gap between our personal and our professional ethics, but we need to close the gap. We need a tighter disconnect between ourselves and our professional persona. And part of my ambition in this is to think about how we can develop a new model of legal ethics, one that better bridges this gap between professional and personal and allows them to come, if not together, then closer together than they presently are. Now, it's pretty easy, I think, to dream up a new legal ethics. Like, you know, if you've thought a lot about the legal profession, you can dream up all kinds of different ways to be a lawyer. But that's the kind of the blue skying. And occasionally we need to think like that. What would a profession look like if we had a completely different ethics? But for me, we can only do that within a context. There's no point in offering these utopian schemes for what lawyers could do. We need to think, what is the context in which lawyers operate, and what constraints does that context put on what we can do as good lawyers, ethical lawyers? And it seems to me the main constraint that is in place is that of the adversary process. We're in an adversarial system. Of course, the adversarial system doesn't describe all the legal process, but it's a large part of what we do. Now, there are all kinds of critiques of the adversarial process. Many of them I would support and say spot on. The adversarial process is more of a problem than a solution. In fact, if the adversarial process is the solution, it's not quite clear what the problem is in that sense. Nevertheless, it seems to me that, I didn't mean to do that. There we go. It seems to me we need to think, what is it to be a good lawyer within the adversarial process? We may be softening the edges, we may be changing a little bit the idea of the adversarial process, but it stands at the heart of our legal process. And so to talk about good lawyers, we need to talk about lawyers who are good adversaries, who are ethical adversaries, because anything else is just a utopian exercise. Now, I've been criticized for saying that I've left in play too much. By acknowledging the adversary system, my defense would be, sure, in a different world, we could do something different, but we're not in a different world. So how can I advance a different notion of ethics within an adversarial system? And so when I started thinking about this, it wasn't really clear where to go, and a colleague said to me, well, you know, there's that whole literature out there about military ethics and the ethics of war. And as a typical law professor, I turned my nose up at that idea, thinking military ethics, you know. Not only is legal ethics an oxymoron, but military ethics is right up there. But nevertheless, I thought, well, I did look at military ethics, because if I'm going to think about lawyers operating an adversarial process, then it seems to me a good place to begin might be to look at the ethics of military engagement and the ethics of war. And of course, one of the things we know is, that's often used, people talk about litigation as war. Litigation is war. Many people initially think, well, surely that's not a road to go down. That's really going to get us into even more problems. But as I looked into this area, I started to realize, somewhat enviously, that these military ethicists, whatever the connection was between military ethics and what goes on in the world of military engagements, but as an ethical pursuit and discipline, they had a lot to tell us. That we could think about lawyering through the lens of military ethics. And so my book is about trying to think about legal ethics with the help, support, and resources of military ethics. And there are a number of initial observations that I think make this a plausible connection. So the military think of themselves as a profession, as a group that are committed to having an internal discipline and a public purpose. They don't simply serve their own ends. They receive power because of the public purposes they fulfill, which is one of the claims that lawyers make. Also, there is enormous role differentiation when it comes to the military. The military do things that no one would think were good to do in their personal life. Obviously, the extreme example is they kill people. And they need an ethical justification for doing that. So this also seemed a fertile area. But the first thing to note about soldiers is there's a distinction that's initially made in all the literature. There's great disagreement within the literature, but one thing they all agree on, that being a soldier is not the same as being a mercenary. Mercenaries are obviously people who sell themselves out to particular causes and follow those interests of the people who employ them. Now, of course, it doesn't take a genius to know that that is awkwardly close to our understanding of what lawyers do. Lawyers act, looked at through the military literature, more as mercenaries than they do as soldiers. In fact, one of the things that lawyers take great pride in is their kind of hands-off approach, not judging the causes that their clients have. In fact, there's a sense of pride in which lawyers remain agnostic about the identity or interests of their clients. And so this initial distinction, I think, is helpful to think about the fact that lawyers are mercenaries, and in fact in the literature, once you look at mercenaries, there are more ethical codes today flowing from the UN about mercenaries than there are for lawyers. There's many more resources and guidance for what mercenaries can and can't do than in fact there are for lawyers. Lawyers are left to their own devices a great deal. So in many ways, the key to the book is the famous phrase, all's fair in love and war. Right? We all know this idea. Don't want to talk about love, you know, maybe things are fair in there, that's a whole different dynamic. But when you look at it, all's not fair in war. There's a massive literature that says in war there are moral constraints and moral values in play. We don't just go off and do whatever we want to do, then we should, even if we don't, observe certain moral criteria. In fact, as Michael Walzer, who's a renowned moral theorist, says, soldiering war is a moral universe. It is drenched in all kinds of values and ideas. And so what I want to do is to utilize that moral universe and switch it over to law. Now what I'm suggesting here is that military ethics can be suggestive for lawyers. I'm not saying we should incorporate wholesale military ethics and just put them on top of legal activities, but we should utilize this area of thought as a way of informing our different thinking about what it is to be a lawyer. And the whole idea comes down to the fact of, as the title of my book says, fighting fair. It's not just about fighting, it's not just about fighting to win, it's about winning, but it's about winning by fighting fairly. And so the large part of my book is about trying to flesh out, substantiate a vision of what it means to fight fair. And I do that by looking at the military literature, the ethical literature, and there's a division there, an obvious division, that fighting fair means it depends upon the ends for which you're fighting, they affect the fairness of fighting, and also that the means that you employ in order to pursue these ends. And so there are three aspects to this that I want to talk about. First of all, there are just ends, that we should only engage in just wars. The second is, in pursuing the just wars, we should only engage in just means. And the third one, which is a more recent development in the literature, is the idea of a just peace. So there are three things I want to look at in military ethics, and then think about how they can help our rethinking of what it is to be a good lawyer. So the first one is a just war. I'm not going to talk a lot about the military literature, but I'm going to talk a little bit more about what it means for lawyers. So within the literature, it can be condensed down that just wars have 5 indicators. Okay, the cause has to be just. We have to be fighting for a just cause. Of course there will be disagreement over what that just cause is, but there at least has to be a defense of what we do as being just. We have to have rightful intentions. To do the right thing for the wrong reason is, T.S. Eliot goes on, is the greatest treason. Right? So it's not only that we're doing the right thing, but we're doing it for the right reasons. We need proportionality. We don't engage in war for any and every infraction. To go to war imposes a considerable burden on those, which is cashed out in the idea of the last resort. War is the last resort. All other means must be exhausted before we go to war. And fifthly, what is important, there needs to be a reasonable chance of success. If we're going to engage in war, in serious military activity, then we need to know there will be a chance of success. So, does this tell us anything about what lawyers may do? Well, it seems to me it imposes what at the moment is not part of our ethical vocabulary or discourse, is the notion that we need to think about, as lawyers, the causes we serve and the clients we take. That we can't simply say that it is our duty, or at least our privilege, to accept whoever knocks on our doors. That we need to have some, but not complete, alignment between what we think is a just cause and the fact that we're prepared to stand with that cause. Now, there's all kinds of issues that I try and deal with around this. I'm not suggesting that you only take on clients who share every single view that you have. But what it is saying is you need to take an ethical stand and defend why you defend the people that you do, or why you represent the people that you do. And this will vary. I'm not saying there's some great standard that says if you represent certain corporations, you're being a bad lawyer, it's a bad cause. I don't mean that. You have to be able to give, though, some ethical explanation about why you're doing what you're doing and why you take the clients that you take. Now, there, of course, can be circumstances where you're in a difficult spot. One of the classics is, what if you're the last lawyer in town, as it were? Does that put different ethical obligations on you? My answer to that is probably yes. And obviously, one of the great objections to this is that people won't be able to get lawyers if lawyers have to line up their interests with clients. But in fact, if you think about it, the people who might have the least just causes have no problems getting lawyers as it is. It's the people who perhaps need lawyers most who can't get lawyers, and there's a way that lawyers can fulfill that obligation by adopting such clients. So military ethics forces us to say something about the interests and the ambitions to which we put our own efforts and resources. We need some explanation, if only to ourselves, that these are just causes. It also says something about competence. We need to feel that we can serve the interests of our clients fully. Too many lawyers take on cases which they know little about. And perhaps even more of a problem, too many lawyers take on too many clients, such that they are spread so thinly that they're not able to give the appropriate attention to their clients. It also means, I think, if we talk about just lawyering through just war and ends, we also need to be litigation shy. Remember that just war is the last resort, and lawyers need to think about all kinds of other ways to resolve disputes without automatically going to litigation. They need to try and convince, persuade their clients that simply suing is not the way to go, especially if you're the more powerful side in any dispute. Then using litigation as an interim threat is very problematic. So I think importantly, lawyers must start to ask the question, who am I lending my talents and energies to? And you at least need to be persuaded yourself that what you're doing is worthwhile. And there are all kinds of things that lawyers can do to persuade themselves of that, but it's an important step. The next thing is just means. So this is the military literature. You can only use just means to achieve just ends, and you need discriminate use of force, and a proportionate balance between action and objective. That we use certain weapons for certain situations. So if you're engaged in various disputes in the world, I mean, one, to use a rather stark, perhaps silly example, is you can't go to the nuclear option right off the bat. Right? There are all kinds of other, this may solve all kinds of military situations, but you can't do that. There can't be overkilling, prevention of unnecessary suffering, selection of only military targets and the avoidance of civilian targets, and the invalidity of retaliatory strikes. Now all these, I think, are suggestive for lawyers to think about what they can and can't do as lawyers. And I think perhaps one of the most important is a question that arises within legal ethics is, do we have duties to third parties? And there's tremendous division within legal ethics. Some people argue that lawyers should only be concerned with the interests of their own clients. Others suggest there are circumstances in which you should be aware of the impact of your activities as a lawyer on those of third parties. Now, I'm not suggesting for a second that third parties should receive the same weight in a lawyer's ethical evaluations as their clients. There's no question to me that the worst kind of lawyer is the lawyer who takes on a client and gives that client a half-hearted effort. You can't do that. You need to be giving your best. But to give your best doesn't mean that you can't take into account other people's interests. The law recognizes some of this in some situations. If you're a family lawyer, you're taking into account perhaps interests of children. If you're involved in drawing up wills, then one of the things you might be doing is thinking about the interests of beneficiaries. But it's asking you to think that there are duties to third parties, and these should be considered. So, for instance, in doing things on behalf of your client, you should assess the negative impact that this will have on other people. You should bring that into the ethical balance. It doesn't mean at the end of the day you will give priority to that, but it's part of your calculation. It's also the sense in which, for just lawyering, you need to be sensitive to the forces and resources available to other parties. If you out-resource other parties, perhaps this should impose ethical obligations upon lawyers. And the best example, I've got SRO, which is self-represented litigants, which I think you call pro se litigants. Then, if you're up as a lawyer representing a client up against a self-represented litigant, this should have some ethical impact about how you proceed. You can't proceed as if, because one of the assumptions of ethical lawyering is the other side will have a lawyer so we can do what we want to do because the other side will have someone representing their interests. Well, if they don't, then the question is, how should that affect you as a lawyer in dealing with parties who are self-represented? I think this is a hugely significant issue because self-represented litigants become a more and more major part of the litigation process. And I don't think lawyers have thought through at all what it means to deal with self-represented litigants. Also, just lawyering may take into account a kind of idea of superior orders. One of the realities of legal practice is that many lawyers, particularly many people who will go from Harvard Law School, will be part of large organizations. And junior lawyers have little sense that they're making ethical decisions or have hardly any ethical autonomy because they're being told to do different things. And so we might want to develop a better notion, which I think exists in some state codes, whereby senior lawyers take much greater responsibility than junior lawyers. Junior lawyers, quote, follow orders. There are limits to that, and there's a whole military doctrine obviously about following orders. But the main thing it tells you is to get to the heart of it, that in playing to win, you need to play fairly. You need to incorporate within your practice the notion that winning can't be the only thing. It has to be done with pride in what we do. And one way to think about it is too often lawyers get into the idea that if they can do something, they should do it. That there are all sorts of options and possibilities and strategies you might adopt. And the idea seems to be for some lawyers that if you can take certain steps, then you should and must take certain steps. Examples would be cross-examining witnesses and how vigorous one was at demolishing witnesses. It seems to me you need to think about that in a way that's much fairer and not simply take the course to say, well, I can do it, so I don't have to justify why I should do it. So again, it's not telling people what lawyers, what they can and can't do. It's asking them, as it were, always to take an ethical breather and to think about what it is they're doing and why. So that's the idea of the just lawyering. And the last one is just peace. There's a lot of literature now in military ethics about just peace. We need a fair termination of hostilities, rightful intention, public declarations at the end of hostilities, discriminate treatment, the idea that the victors take advantage of the losers. Who's going to be held responsible for a different activity, and proportionality. I mean, these things seem to me fairly obvious in things like family law. If you're a family lawyer, it seems to me you should have some obligation to ensure that you lay down a settlement, and this will be true of other areas, but you lay down a settlement which provide not just the end of hostilities, but the grounds for continuing peace. That we will establish a regime in which the parties can go forward and not be in dispute again in the near or middle future. So again, military ethics, I think, suggests ways for lawyers to think about this. Some of those ways are, obviously, you need to be a good winner as much as a good loser. And I think, obviously, a lot of this smacks, it may seem, of kind of sporty vocabulary. I could do that, but I sort of hold off from doing that because I know that's not everybody's cup of tea. But we need to be good winners, good losers. Victors can't lord it over the losers. There is an ethical dimension to the settlements you impose. You need an eye to justice. So we need fair settlements. And obviously one of the things that lawyers do more than anything else is negotiating. And the whole idea of ethics introduces an element of fairness to negotiating that seems to be lost, particularly in situations, again, where there are self-represented litigants. Lawyers justify much of what they do, which they'll call bluffing, as opposed to what other people might call lying, well, because the other side have lawyers who can counteract or countermand this and provide a dynamic. I want to suggest we have to be careful about that. Experienced lawyers against inexperienced lawyers, experienced lawyers taking advantage of inexperienced lawyers, and also inexperienced clients. So all of this, all I'm trying to do is suggest that we might be able to think differently about legal ethics. So by way of conclusion, there are obviously limitations to this. I try and do a defense of why we should think about the good soldier and the good lawyer in the same way, and that there are sufficient similarities that outweigh the dissimilarities that exist between the two. Also, the fact that it would seem that in war people ignore ethics all the time is really not a strike against what I'm trying to do. Right? Whether the military are ignoring ethics is really not part of the story. Also, I think this would close the gap, but it wouldn't extinguish the gap between professionals and between professional and personal morality. And of course, it's something of a stopgap measure because it may well be that the adversary system is at the root of our problems, and I've held that in as one of the operating premises. So, I'm going to end on a quote by a graduate of Harvard Law School from 1994. People know who this is? So he's one of your lot. He's a famous alumni. Who said that? Obama? Yeah, it's Obama. This is Barack Obama. His acceptance speech for the Nobel Peace Prize. And it has some resonance. It fits nicely with being here, but it has some resonance. I do not bring with me today a definitive solution to the problems of war law. What I do know is that meeting these challenges will require the same vision, hard work, and persistence of those men and women who acted so boldly decades ago. And it will require us to think in new ways about the notions of just war and the imperatives of a just peace. That seems to me to say something about the burden that lawyers, legal academics may face when we think about legal ethics. I'd be very happy to answer any questions or criticisms or whatever.
So what areas of law do you think are more likely to fit within your rubric than others? You mentioned family law, but
Yeah.
for example, criminal defense or corporation versus corporation, but what do you think?
I think it's obviously a good question. Let me preface it by saying too much of legal ethics uses as its paradigm example criminal law. And I think that immediately gets us off down the wrong road. Because there are interests and values in play there that don't play so well in the rest of the picture. So I think thinking about legal ethics through criminal law can lead to more problems than solutions. But I think this has, I used examples of family law, but I think in the area of corporate law, the kind of antagonism, the battles that go on, I think this fulfills a function. But the main thing is, whatever area of law it's in, it's trying to pressure lawyers to say that simply taking on clients and fulfilling their interests cannot exhaust our ethical mandate. There needs to be more. Now, it may be if two corporations, large corporations are involved with a battery of lawyers on each side, then people can say, hey, go for it. They'll both check each other. But I still don't think that's the case. I think we have to serve a broader public interest. But I think this can apply to most areas. Obviously, anything that likely is around litigation is obviously a more appropriate area that we could think about some of these issues.
I want to sort of challenge you on this, because I think certainly it has applications in the adversarial setting. In the corporate setting, if we take the world of lawyers, and we set aside for the moment all those good doobies who want to do public work and public access and public justice, most of us are motivated by one thing, and that's money. We want to get paid a fee and a fair salary for our service. And the only thing that's going to change the way I behave in thinking about not only my client, but the results that I'm going to achieve by my client would be if I'm going to be exposed as a lawyer to the behavior of my client. And we saw this recently with public finance lawyers and disclosure documents. And the SEC said, look, you can do all this stuff. And we saw this with the mortgage-backed financing. We enabled people to do bad things because we could do it. And there's nothing wrong with that. It's totally ethical. We gave them great legal opinions, Standard & Poor's, all of them. And we did the same thing with a lot of the municipal bond financings and the failures of Detroit and other municipalities around the country. The only way I'm going to change my behavior as a lawyer who's going to write that opinion, who's going to give the bank the ability to buy bad paper and sell it, would be if the courts have a direct right to sue me and penalize me and disgorge me of my fees. All this stuff is great, and we can have all the ethical rules we want, but if you're not going to enforce that, then I don't think we're going to change our behavior.
Well, first of all, I obviously think your opening premise is half the problem. That as long as lawyers think of themselves as primarily in a business, right, and that the bottom line is always going to be the money they earn, then clearly that's as much part of the problem as the solution. Now, in saying that, I don't think by any means that lawyers shouldn't make good salaries or make money, whatever. But I mean, presumably we expect more of them as we expect more of doctors or other professionals and soldiers to say, of course you're entitled to a reasonable living, but you need to do so by acting in an ethical way. And I think one of the ways that we fail is, I think you're right, about enforcement and discipline. One of the things the legal profession is very big on are grand statements about the honourable profession, but if you look at, I can't talk a lot about the US because I'm just not familiar, but if you look at the enforcement practices in Canada, they are abysmal. Right? There's no monitoring as such, it's always in response to a complaint, and of course litigants are reluctant to make complaints to the law society, as we would call them. So I think that the whole idea of enforcement and discipline is hugely significant in doing this. And if you look at some of the great sort of scandals, Enron might be one of them, right? You see accountants firms going down, but the lawyers are nowhere to be seen. We've got the Volkswagen fiasco at the moment, and the question being asked is, where were the lawyers? Of course, these are very smart lawyers. They, you know, the first rule of lawyering is cover your ass. Right? I mean, everybody needs to know that. But I think that obviously I'm trying to challenge that. And I think one way to challenge it is, I know this sounds so weak, is we need to provide a context in which people think ethics is not something that occurs when there's a problem, but ethics is an integral part of my self-identity as a lawyer, because I don't think that's the case right now. It's I want to do all these things, or I better look what's ethically accepted. So I think changing our self-understanding of what it is to be a lawyer, that we need to enforce this collectively. It's not always an individual obligation, it is a collective obligation in doing this. Person at the back, and then
Well, I think both from a normative perspective and from a pedagogical perspective, this is I find this very ingenious. It provides a good narrative for explaining to students ethical dilemmas, and also to lay out foundations for ethical discussions. My question, I think it builds on some of the previous questions about, and it has more of a sociological tone. So I don't know if you did any kind of empirical investigation about how and to what extent that framework resonates to different kinds of lawyers.
The answer to that, I mean, I didn't. That's easy to answer. But if we accept sort of the fact that I've been around a lot and dealing with lawyers and the profession, you get a sense of what practices are.
Because I think it would be a good initiative to take this idea of lawyers as a hypothesis to test the 4 different kinds of lawyers.
Yeah.
And because I envision, for example, those lawyering for the leasing power clients, they can see themselves as lawyers, but that means something totally different than that standard of soldier that you're using.
Right, I think all that is sort of true. I suppose what I'm asking really is that we think about ethics in a different way. What it is to be ethical, we start to change our understandings of the framework in which we think about what is ethical. And it seems to me, I think we have to be careful in kind of valorizing everybody who does say public interest. They're all the good lawyers, and then all the bad lawyers are on Wall Street. I think that's a mistake. I'm not saying you're saying that. I think of people in my own kind of jurisdiction, Toronto, Ontario, where I don't think that necessarily is the case, because whatever your interest you're working in, you need to act in a certain way. There are good lawyers in this, bad lawyers in that. But I think one of the things that I do find troubling is the resistance of the legal profession to talking about these matters in a larger sense. They're very happy to talk about confidentiality, conflict of interest and the like. It's pretty safe territory. But then once you start going to a bigger picture of what lawyers should do, because it is such a lucrative business, then it becomes problematic. Yep.
I wanted to go back to a question that took a left turn and I would have taken a right turn.
But I'm taking the left turn. So it's
well, up and down turn,
sure.
Round and down turn. The heart of the analogy that you're making is really litigation to war, but a majority of what lawyers do is not litigation at all. And some of your examples, somebody writing a will and taking into account the interest of the beneficiary, or an example of inventing collateralized debt obligations or whatever, most of what was going on in Enron had nothing to do with litigation. It had to do with compliance with other kinds of processes and dealing with other kinds of challenges to your question about what do I need to be a good person. And I guess you started off by admitting that adversarialism is a big part, is a core, but it's not the only aspect of what lawyers do. It's bigger in sort of theory than it is in practice in some ways, because lawyers like to think of themselves as litigators. So how do you either extend your analysis to include all this other world, or what do we do in a world where there are multiple analogies to be made, so that depending upon how you define what universe you're operating in, that tells you what the gods are who are the rulers of that particular universe?
No, I think that's obviously an astute comment. I suppose one thing I want to say is a lot of non-adversarial lawyer work takes place in the shadow of the adversarial process. Lawyers, when they're in transaction mode, are often thinking about, lawyers think about what's going to happen when it all goes wrong, in that sense. So I think it has more of an influence. But I think it's something that I need to think more about as the kind of second phase of this. But again, I think it does have application for what lawyers do, because at the heart of what I'm doing is I'm not sort of saying we must follow the framework of military ethics. It's part of a larger project of introducing a stronger, more substantive basis of ethics into what lawyers do. And so this is more of an illustration. I'm not saying this is the exclusive way to do it. I'm saying here's a way to think about it. And in thinking about it this way, it shows that we presently don't think about any of these issues in any great detail in a great way. And so I'm trying to provoke that broader discussion. If other people have different frameworks that I think can achieve that, I'm delighted with that. But I do think I need to think more about what's called the transaction-based areas of law, which is huge, in thinking about how this might apply as part of the larger idea of ethics. Yep.
So picking up partly from one of the questions before, and my major concern is I love the idea, but I'm just really worried about the roadmap. I mean, it's a huge issue. It's kind of the bigger frame issue. But if we have to make a substantial progress in it, we need to do more than just leave it to the conscience of an individual lawyer. Because those who are conscious enough are thinking about these issues at an individual level anyway. The question is, how do we institutionalize this idea? How do we make substantial progress? And I'm just thinking, and I mean, I'm thinking other ideas that you thought of, but as a gentle suggestion, I'm thinking, because we know in humanitarian laws, we now have written down laws on proportionality and different things that you talked about. Don't we, or can we not come up with some sort of model rules that, let's say, if the Bar Association of a particular country didn't want to have a discussion on this, what would it mean, including in their existing legal code of ethics?
Well, that's a very good suggestion that I haven't fully thought about. So if I'm hearing you correctly, part of my project might be to say, well, and one of the things I do is I use 3 different codes, US, Canada and the UK, is to say, well, what would a different code look like? And I haven't done that. I think in part because I've been a little shy in thinking, I'm not sure that the way to get the kind of ethical thinking I think is appropriate is by reducing it to a set of rules, because I think that's part of the problem with lawyers. Right? They say, here's a body of rules, and we're good at manipulating, changing rules. But I do think it might be, I do think it is a good suggestion as I think about now to think I should have some concrete proposals. And this is quite a slight book, but I welcome and appreciate that suggestion. Maybe we've got time for another question or so. Yep.
Yeah, so I found this very interesting and imaginative and open up a number of pathways. And one pathway for me in thinking about this and some of the analogies you brought up was you compare lawyers to soldiers, and then you bring in this just war analogy. But soldiers, as we know, aren't the ones deciding whether a war is just or not. You know, this is more about the sovereign. And if you think in this analogy, who is the sovereign? You know, it's the client. And maybe one thing that I took away from this talk was thinking about how to change the culture amongst clients about what a lawyer should or should not do and what is a just use for the legal system. And this is a kind of a broader sociological, and that can be partly lawyers educating clients, but it can also be a range of other kinds of initiatives you could imagine, including rules around vexatious litigation, to just broader, how do we talk about law in high schools? How do we talk about law in colleges, etc.?
Well, I think that's well put. Just to go back to when we came into Boston on Sunday, one of the things the custom officer said was, he said, well, you know, you lawyers, he said, you know, you do all kinds of things. But he said, but when I want a lawyer, that's the kind of lawyer I want, who's doing just dealing with me, all the other stuff that can help other people. So I think clients do have that. They have poor opinions of the legal profession often, but of course when they're in trouble or need a lawyer, they want someone who's a pit bull and ready to do things just for them. And I think that's an important part. Now, it's tough enough thinking how you re-educate lawyers. The idea of re-educating clients is even more of a problem, something that I hadn't thought about. But I think you're right. I mean, one defense, of course, that lawyers make is that we're just doing the bidding of clients. We don't tell clients what to do. I mean, I don't think that's true, particularly in most areas. Lawyers tell clients what their interests are, because clients are never clear what their interests are, and one of the things lawyers do is create those. But I think it's a good question about that we need to take into account what it is that people want and how that would fit. Because the real challenge is that I'm constantly confronted is, do you really want the legal profession to be the gatekeepers for justice? Because the performance of lawyers to date has not been encouraging in that regard. Right? So I think those raise important issues that I need to think about.
So we are entering the world where almost everything eventually is going to be put through some type of data analysis. And I wonder, in your next rendition of this, if you might think about applying some statistics and some type of Watson-like answer if-then to this. Because you said that there's 4 things: just cause, just means, just peace.
Yep.
I guess that's just ends, it's the same thing. So 3. And I wonder if you could go through, even with some of the information in your slides, some if-thens. And it would be interesting to see in different areas of law where when you only have one of the 3, you still might be pretty happy compared to where we are now. So if you have a just cause and just means, but the piece at the end of the day only goes towards one side, maybe that's still a success story. And I wonder if mathematics might help you work through some of the practical and theoretical points that have been brought up today.
Yeah, I'm not keen on that term towards the sociological and the mathematics of the database. I'm instinctively sort of resistant to that, maybe wrongly so. But I think one of the things I always try and tell students is that the most significant ethical decision you ever make is the law firm you join. And nobody thinks of that as an ethical decision. Because depending on the law firm you join, really the die has been cast about the clients you have, and therefore the causes that you are involved in. And I try and notice it because I say that once you've gone into a certain kind of legal practice, you're committed to give your clients the best service that you can. And so for me, I would concentrate most of my effort upon how lawyers decide upon the kind of work that they're going to do, because that has massive implications for everything else. All the rest of the ethical dilemmas, they don't disappear, but they fall into a certain pattern depending upon the kind of legal work that you do. So students say, I want to go into environmental law, and of course I say, well, what do you mean by that? You want to go, which side you're going to go into, right? You're going to be representing defendants, you're going to represent plaintiffs. So I would put most of my kind of lobbying effort, as we said, around this idea of causes served and clients taken. I think that is hugely significant. And of course, a comment that I haven't really said is, one of the difficulties we face is there's nothing called, the lawyer. The lawyer now has so many incarnations, and the challenges for these different incarnations and the moral dilemmas they face are so different. If you're a New York Wall Street lawyer as compared to a lawyer in a struggle here as to where I can think of Canadian examples. But if you're in the middle of nowhere as a lawyer, you're not really doing the same job at all. And so one of the things we need to think about is not just to have a legal ethics for everyone, but to tailor our legal ethics for the context in which people work. Yep.
Well, first, thank you so much, Mrs. Hutchinson. I felt like I'm back to Osgoode last.
Well, that's good. Yep.
I wonder if I had a sort of experience while working in developing countries. So just going back to each point, yes, we did believe in the causes by taking the clients on. It was a corporate / dispute resolution matter, but we were not competent in dealing with the corporate aspect of the disputes. But thinking that because we don't want to lose the litigation and dispute resolution aspect of the case, we had to sort of play with the rules and to introduce ourselves that we are the competent lawyers. We've taken on the case. The corporate part was very small. The dispute part was really good. We did an absolutely good job, which goes back to what you said about reasonable success. We did believe in the reasonable success part of it. But up to this day, my concern is, what if there's something comes out of the corporate aspect because we were not competent to advise on? And I think back then, I did raise the ethical issue when we were taking on this client. But I remember my partner said, but that's everyone does. Like, all the law firms, that's how we operate. And I think this is the problem in our system, especially when it comes to developing countries. Huge competition between the law firms, boutique and dominant law firms. And you just ignore some of the underlying ethical issues.
Well, I'm sure that's true. As a comment, I think I want to suggest, well, two things. I think competence has not been given its just desert in thinking about it as an ethical matter. Right? I think lawyers often like to think they're the jack of all trades and can move between different areas. I think that's a problem. But I also think it's a problem that just because the danger is if you think you're serving a good cause, you can do things to advance that cause, the means of which might be dubious in other categories. I think that's a particular temptation for lawyers who are working in sort of public interest work, because just because you're doing that doesn't mean that the ends justify the means, as it were. But again, I think it's about my ambition, if there can be so grand as to that, is to simply get us to think about, one, not only that the existing model is inadequate, but to just suggest ways in which we could think of a new model to do. And one of those is finding fair. Thank you.
Thank you.